Hi, welcome. Today we're going to have a webinar called The Intersection of Trust and Family Law. For those of you who've listened to my other webinars, as you know, I'm a fiduciary litigation and administrative lawyer. I deal with some administrations of trusts, probates, and guardianships, but primarily work in when there's disputes and there's adversarial proceedings or lawsuits involving trusts, probate, wills, and or guardianships. Over the years, with both trusts becoming more popular tools of use by folks, and with dissolution and family law proceedings becoming more and more prevalent, it seems like there's been more overlap and more issues that I've seen where a good understanding of basic trust law will help and dealing with some of the family law issues, and in reverse, understanding a little bit of how family law works and planning to do trust work and then deciding what kind of claims a trust may want to pursue. So the purpose of today's webinar is to give an overall view of some of these issues. Within an hour, we can't go in depth of all the intricate law and theories that go into trust law and family law, but the goal is to get a good basic understanding and start thinking through some of the issues that can arise and how they may intermingle and possible solutions and things of that sort. As always, I encourage participation. If you have any questions, please pose them, and we'll try to answer them during the webinar itself. If for some reason we can't get to that, I can always follow up with you later on with an email or a call. So with that, let's get started and look at what our agenda is going to look like today. So first, we're going to go over some basic provisions of the Florida Trust Code. For those that aren't as familiar or never delved into it, to look at what the different terminology used in the Florida Trust Code might mean. I recently have worked co-counsel with some divorce dissolution proceeding attorneys, and it was kind of an eye-opening moment for me to realize I was throwing around trust words and terms that weren't as familiar with them. As they did, they threw around terms that are popular in dissolution proceedings that were not as known to me, and some terms that actually we found they sound similar, but they mean different things. So we'll start with the basics today and start with our Florida Trust Code and some basic definitions and format and how we use the Florida Trust Code and trust law. Then we're going to delve into just comparing trust law and dissolution and seeing how the two can overlap. Section 3 today, we're going to look at trust law and how it can apply in adoptions or guardianships for minors. Then we're going to look at trust law and premarital agreements, which has become a hotbed of litigation and case law lately. And then, as always, we'll conclude with a wrap up and another opportunity for you to pose questions at the end. So, basic tenets of trust law. What is a trust? And when is the Florida Trust Code applicable? Well, a trust, there's different types of trust, but in generally speaking, we have express trusts, which are stated in writing or in some cases verbally, but they state with a specific purpose where property is transferred to be held for the benefit of someone else. That's a very simplified trust. There can be other provisions, obviously, that control how the property will be held, administered, managed, when it will be, distributed and things like that. But in simple format, a trust is a direction to take for a third party called a trustee to take control over and manage property for the benefit of another party. Even though a grantor, the person that actually creates the trust, the trustee, and the beneficiary can sometimes be the same person, with one exception. If the grantor is the sole beneficiary, then you really don't have a trust because there's no third party involved or that will have some kind of interest or potential interest or future interest. So therefore, you've only created something that you control, and it's just for your own benefit. So that's the law just looks at that as nothing really. An express trust, like I just said, is covered under the Florida Trust Code, and also our charitable or non-charitable trusts, which we'll look at closer to those definitions later on. And any trust that may be created by law or in a judgment with express terms. An easy way to say, well, isn't all trust express? Well, there is something called a constructive trust, and that's not covered by the Florida Trust Code applicable, or applicable under the Florida Trust Code. So what's a constructive trust? It's a trust that's created as an operation of equity. Under circumstances where the judge believes that a trust should be imposed because the circumstances are so unconscionable or inequitable that the court's going to suppose that these assets are going to be held in trust for the benefit of another. If you need an example where I've seen it come in the context of my practice of law and probate and things is you have a parent who wants to help their child out who can't get a good mortgage rate. So they take out a loan for the property, and the property has to be titled in their name per the mortgage or's requirements. Then unexpectedly that parent dies, leaving in a property that's technically in their name. But the child has put the down payment, paid all the payments, paid all the taxes, and it clearly was treated just as the child's property. The person who died and whose name it was in never operated any control or possession or responsibility for the property other than on paper. The court can impose what they call a constructive trust and say, well, technically, yes, title was in the name of the decedent, but he was holding it just in title for the benefit, and it really was for the benefit of this person that, the son in case of my example, the child, and then impose a trust and essentially transform the title to that property. Again, that's an operation of a legal equitable principle. So the Florida Trust Code is not applicable if the trust deems that some kind of constructive trust is in place. It doesn't apply to land trust either per 736.0102 subsection 3. Land trust, if anybody's ever had any experience with them, and certainly we can't go into too much detail today because you could do a whole webinar on land trust. But they're set up where you own property and you can be multiple holders, and they're a very special animal. And they have their own statute that governs them, and so they've been accepted out under the Florida Trust Code, which is in chapter 436. So if you're dealing with the land trust, you don't have to bother looking at chapter 436 to see if there's applicable provisions. So already, even in describing trust, I've used some of these terms that we sort of throw around if you do fiduciary work. But let's make sure that everybody's clear on what they mean. We have settlers versus beneficiaries versus trustees. These are sort of the players that are involved in any trust. A settlor, sometimes the word grantor is used, is a person who creates or contributes property to a trust. In your classical example, I want to, I have a property I want to hold in trust for someone else. So I transfer it into the name of the trust after I've created the document. I'm the settlor. And clearly you can have more than one. It's not uncommon for husbands and wives to be joint settlors or grantors in trust. The beneficiary, that's the person who has a present or future interest in the trust or holds the power of appointment. So depending on how the provisions of the trust, the beneficial provisions are written, you could have someone who's, entitled to income today, maybe even entitled to evade principal. But when that person dies, then maybe someone else, maybe their children or some other person that's been designated in the trust. But until that one person dies, or reaches a certain age, or whatever the provision says, the other people named don't have an interest until that event happens, but they have a future interest. And there's provisions in the Florida Trust Code and Florida Common Law that talk about a trustee having to weigh the duty owed to the present beneficiary and the future beneficiaries. If you give the present beneficiary all the money, maybe imprudently, future beneficiaries can complain that you should have been looking out for them too. But then you have an immediate obligation to the beneficiary where maybe you're supposed to take care of their needs and to a certain degree their wants. So that can be a tricky when you're dealing with present and future beneficiaries. And then who's the trustee? Well, I give you a definition here that I pulled out of common law because the statute is uses the word trustee to define trustee. But a trustee is the person or an entity, because we have professional trustees such as banks, and they're charged with carrying out the administration of the trust by the terms of the trustee. But just to give you an example of what the statute says, the definition under 736.0103, subsection 27, it says trustee means the original trustee and includes any additional trustee, and any successor trustee or co-trustee. So that definition didn't really help. So I pulled from the other common law and case law. And again, for those who don't know, even though we refer to Chapter 436 as the Florida Trust Code, it doesn't supersede common law and in most respects, and supplemental to that in most respects. So really, when you talk about Florida trust law, it goes beyond just the code. So trustee, if it can, as you can probably already guess, has fiduciary duties. If they're holding property for the benefit of others, they have duties to both the settlor, the benefit to adhere to the terms that the settlor imposed, to the present beneficiaries, some duties to future beneficiaries, as alluded to, and because of that, they have a duty of care. To take care of the property as if it was their own, to marshal it, to protect it, to insure it as would be necessary. They have a duty to account, depending on the provisions of the code. Provisions of the trust. The code's a default is once a year accountings. The provisions in a trust document can provide for something different, but there's always a duty to account. And to a certain extent, a duty of transparency in the sense there's a provision in the code that they should share any information that's reasonably requested for a beneficiary to ascertain, or the nature of the trust, its assets, and how it's being administered. There's a duty of loyalty. And I think the flip side of that's a duty of impartiality, to be administering the estate for the benefit of the beneficiaries and not for yourself. And that you have to avoid conflicts of interest. Sometimes that can be a little harder, especially if there's spouses involved, if there's children involved, if you're a trustee, but it's your grandchild that's a beneficiary. Or an adult child that there's sometimes there can be conflicts that arise where their interest and your interest may not align. And of course, but to administer the trust, your decisions have to be done with the duty of loyalty to the beneficiary. Prudent administration is a requirement under the Florida statute, and you've probably heard the term prudent investor rule. If you deal with any professional asset management company, this is their Bible, so to speak, the prudent investment rule. But it's prudent investment administration is required under section 736.0804 Florida statute. And again, it's in the way a reasonably prudent person would invest and manage the assets. So let's say you're in a situation with trust, and you need to change some provisions, or you're having problems administering them appropriately, or for the benefit of the beneficiaries because there's been a change in circumstances or a change in law sometimes. This became an issue in 2010, and when there were changes in estate planning related laws, estate tax laws, where there was things that a trustee could take advantage of if they did certain things, made certain payouts at certain times, take advantage of huge tax benefits, but perhaps the trust didn't expressly let them do these kind of things. Sometimes it comes up because a beneficiary, their needs changed completely, maybe due to an unanticipated disability or maybe an unexpected death. Things like that, and the provisions as written are seem to not run or seem to run counter now with what the grantor was trying to accomplish. So sometimes you can modify trusts, and there's judicial ways to do it and non-judicial ways to do it. The statute itself here that we're dealing with, 736 Part 4. Generally speaking, that's applicable to trust created on January 1st, 2001 or after. Before that, you're dealing with common law. And just not to get into the intricate, you can look at the statutes and see. But these are some reasons why you could likely get judicial modifications. There's a tax purpose to be achieved. The trust has become uneconomic as administered. Either the assets have been dwindled, or to administer in the way that it's required, it will become an economic burden. There's something that can be done, and all the parties, interested parties, are in agreement. And by interested parties, that would be the trustees, the beneficiaries, and to the certain extent, the grantor, if they're still alive, and it's and things like that. Of course, there's can be non-judicial agreements when it's in the best interest of the party and it doesn't run contrary to the grantor's requests. Essentially, that's an agreement between all the interested parties. So if you're interested, you have a trust that you want to modify, and there's no longer any provisions that are applicable that would allow someone to modify it, either the trustee or grantor. You can look at more closely at this part for the Florida Trust Code and see if that you qualify under any of those provisions. And again, as a reminder, there are some provisions under the common law, and they're still applicable to trusts that were created prior to 2001. That are of similar nature when an equity essentially would dictate to allow changes to fulfill a grantor's purpose and not waste. So I've already started talking about some different kinds of trusts. So let's look a little closer at what kind of trusts that you typically are dealing with in any context in Florida. There's tons of different kinds. We've mentioned a couple like land trust already, but these are what I've tried to do, that probably some of the more common ones that you're going to come across. First, you need to understand what's revocable versus irrevocable. Under the Florida statute, something's revocable if the grantor, the person who created the trust, can simply revoke it without permission of any other party, including the trustee or the beneficiaries. Most trusts that people do for estate planning purposes, generally speaking, and more simple estate planning, are going to be irrevocable trusts. They're set up so there's provisions in there for after death, but they're meant, the grantor wants to have complete control over the assets and freely be able to amend or revoke the trust as they deem fit up until they may die. And then, of course, upon death of a grantor in a revocable trust, it usually provides that the trust becomes irrevocable. And that's what we deal with in probate a lot, when these testamentary trusts or trusts that were set up with provisions that say that what will happen after their death, they become irrevocable. But you can create an irrevocable trust while you're still alive, and it's irrevocable from the moment you create it and fund it. Why would people do this? Why would you want to put something in trust and then not be able to undo the trust no matter what happened. What if you need the money later on, or what if you need to recapture that asset? Why would people do that? For different purposes. Sometimes for some tax benefit purposes, sometimes to protect or attempt to protect assets from creditor claims, sometimes per agreements, and that comes up sometimes in dissolution agreements and things related to that, which we'll get to a little bit more detail in the next section. But while irrevocable trusts are not someone's go-to normally for estate planning purposes, they certainly can have a purpose for that. Testamentary trusts, I just alluded to, they're trusts that have provisions in them that dictate what happens to assets upon the grantor's death. Their common estate planning has a will that leaves everything to the trust, and then the trust says everything that's in trust before and after my death, it goes to whatever the beneficiaries are once I die. Before death, usually it's the grantor has free reign over the property and can move things in and out as they please. Charitable trust, as the name suggests, has a charitable purpose. That's what a charitable trust is for. It's set up, and trustees, usually more than one, holds property for the benefit of some kind of charity. There's you can get more details on what charitable trusts are in section 7360405 subsection 1 of the Florida statutes. And as you can already see, you can have a mixture of these different kind of trusts, different provisions. Not the whole trust necessarily is charitable, but maybe there's a provision in your trust that has charitable aspects to it. The next one I have listed here is special needs trust. What's a special needs trust? Well, it's a trust that's set out for the benefit of people with disabilities, and those disabilities can be mental or physical, or someone that's chronically ill. And they're set up, and their provisions are set up so with the hope, if you do it correctly, the hopes that the benefit that they have from this trust doesn't go against their eligibility for SSI disability and certain benefits. This is a certain specialized area. Certainly anybody who's looking to want to set up a special needs trust with this purpose in mind for another party, I highly recommend you get good advice on that. It's easy to mess those up. And I left one off here I should have put, and that's spendthrift trusts or spendthrift trust provisions, which you'll find oftentimes in these other kind of trusts that I've just listed. Spendthrift trust, what do? They're meant to, they have provisions in there where it doesn't let the beneficiary have any control over their interest. They can't sell or transfer their interest, and the hope there is to keep that creditors of the beneficiary from getting to their interest. These became popular, probably in the last 50 or 60 years, for people setting up trusts, but no, the beneficiaries have problems with money, managing money, are likely to get a creditor at some point, likely to want to always be coming to the trustee to pay off a credit card bill or some kind of irresponsible spending habit. So they're set up with that kind of idea in mind. Let's protect the beneficiary from themselves, and with those restrictions to generally keep creditors away. There are some exceptions, which we'll get into here in a little bit in the next section. So again, there's many types of trusts. These are just probably the ones that I personally come in contact with the most often, and I'm guessing that most people that do any kind of work in the fiduciary or family law area see the most. So section 2, trust law and dissolution. Let's see how we have some overlapping here. First of all, you have trust assets. You have assets that's been transferred to a trust. Are they marital assets? Well, it depends. And there's not a black line rule per se. But generally speaking, this is when it's not going to be considered, a trust asset's not going to be considered marital asset. When the trust assets were funded by a third party for just benefit of one spouse, for example, an inheritance, um, or um, or when there was a transfer to the trust prior to the marriage, and especially if it was irrevocable, and there's no commingling with marital assets, that has a pretty good chance of standing outside the marital assets. And then the control factor. If you're exercising control over the assets, if the monies from the assets are being used to essentially fund the marriage and the expenses of the marriage, this kind of commingling and control by one spouse during the marriage is more likely to put it in the category of being found as a marital asset. So to answer the question, are trust assets marital assets? The answer is our lawyer's favorite term, maybe. Depends on the trust, depends on when it was set up, who set it up, how it was funded, and how it's been treated since the marriage, and to what degree there's been any commingling. So, let's fast forward. As you know, in divorce proceedings, you can reach agreements that, short of having a final hearing and a judge make certain findings, you have a lot of leeway in how you want to divvy up the assets with some minimum provisions for child support and things like that. Something I've seen a trend in recent decades is, especially when there's some complicated assets involved, and maybe some distrust on how some assets will be held by the other spouse and managed by the other spouse, that you can create trusts and hold them in trust for the spouse. And maybe this is done so that the assets are income producing and the income's used responsibly by the spouse. They can't access it except for, some kind of standards such as health maintenance support, with the idea being that you'd like that, the asset to be managed responsibly by a third party, so that there's, the future beneficiaries such as the children. So they can be used in dissolution agreements if there's a problem with divvy of access and one spouse is just having a hard time getting over. I think they're going to waste this money. I think that, ultimately my children will suffer. The trust can be set up and provisions can be made that maybe gets you over that kind of hump. So you can also do it for estate planning purposes. You may find, depending on the nature of your assets, there may be some tax benefits. For example, if one spouse has or is required to maintain a substantial life insurance policy, like $5 million, something that could eventually get you in the estate tax realm, there may be a benefit to transferring the life insurance policy today to a trust. They're commonly called ILETs. They're very specialized in what they're doing. They're designed to hold a substantial life insurance policy. The taxable transfers today is not the asset's not worth that much. It's only worth, the 5 million upon death. So the thought is you transfer today, it's out of your estate. It will benefit, whoever's the designated beneficiaries at a later date, but it doesn't go against your estate for that full value. And if they're set up correctly and depending on how much cash value is built up, they can be self-sustaining. The cash value that the policy accrues every year can be used to pay the premiums. So those can be used in dissolution proceedings as well. If you have a substantial life insurance policy that you might want to transfer for both tax purposes and to ensure that, that there's a third party that's responsible for that life insurance policy that will make sure it gets paid, premiums get paid, and that it stays as it is, and that the beneficiaries can't be changed without that third party, who would be in charge of making sure it's administered in accordance with whatever the agreement was in the trust. So those are some examples of where I can see what you're in the dissolution part of the proceedings, and you don't have trust, but maybe you want to create some trust, especially if it helps parties, come to their own resolution on their own property distributions. So let's look at how trust can be used when we're dealing with minors. If you do any kind of guardianship law, adoptive estate, adoptive, dealing with adoptions, dealing with creating trust just for the purposes of taking care of minors, um, trust and understanding how trust can work and how they compete with other duties that the players have in these scenarios is sort of important to work through. Um, for example, you have you can have a minor who's lost their parents. They can have a guardian. Their parents or their adoptive parents can be, can be their natural guardian of the person, but after a certain threshold um, of money's involved, then you have a guardian of the property, which could be the parent if the court so chooses. But that doesn't necessarily get rid of a trustee or affect the trustee of a trust that's been set up for that minor. So let's go through all these terms and these players, and let's see how they may interact. I've noticed this has become more and more popular in guardianships that I'm dealing with. You have the Uniform to Minors Transfer Act, and we're not gonna get into that because that is its own set of rules and everything, and its own statute. What I want to look at is when you have trust involved, or you want to set up trust for the benefit of minors, and then you have these other players that have certain duties and fiduciary duties. How do their duties and their responsibilities mesh up with that of a trustee? So, why would you want to use trust for minors? Why wouldn't parents or whomever is responsible for the minors just, use their funds at will? Well, there can be a number of reasons. We just looked at one example. If you went through a dissolution, you may agree to have trust for the benefit of minors, just to make sure that both spouses or neither spouse is taking advantage and of the minor, and that both parties are satisfied that the minors are going to get the benefit of the property. But they can be used to set up trust for future expenses, for medical emergencies, college funds, things like that. They also, one advantage they have is that you can set them up so that children don't have access or right to request money until they reach a certain age. The law majority in Florida is 18. But in a trust, it's not unusual to have provisions that they have to be at least 21 or 25 before they're able to act on their own behalf and have it, and make a demand for certain beneficial interests. That's in a recognition as some parents, as if you've ever had teenagers, as I have, it's hard to remember my sons at age 18 and thinking about that they're responsible enough to be in charge of a significant sum of money or have a right to a significant sum of money. We still, in some of our minds, 18 is just not mature enough, even though the law in Florida is the default is they are. So trust can be set up to take advantage of that instead of just leaving something out to the minor outright. And again, if you want to make sure that another party is using money it's supposed to use for the benefit of the minors, you can have them transfer in trust, and then the trustee's got a legal and fiduciary responsibility to make sure it's used for the minor. Now, and I've seen this come up in the case of adoption. We have adopted parents, but there was a trust maybe from a deceased parent's estate that's in place, and there's a trustee, and they have provisions that say that they're going to deal with the care of the minor, and they have a standard that they get either all the beneficial interest, or they get for health, maintenance, education kind of standard. Adoptive parents will still be just like any natural parents. They're still the natural guardians of the children. They're still the guardians of the person themselves. They dictate their schooling, where they live, everything that deals with them as a person. But presuming the trust has assets over $15,000 or $30,000, the trustee's the person that's going to deal with the trust document or the trust assets. The parents can make requests on behalf of the beneficiary as a representative. They can point out that they need help or maintenance or education support, but they have no control over the money whatsoever. The money's held in trust. The trustee administers it in accordance with the trust document. The or natural parents in that extent are not administering or managing those monies or assets. They're at the mercy of whatever the provisions say in the discretion of the trustee. Then you have trustee versus guardian. What about when you have a guardian of the property in person? In the context of guardianships, if you're familiar with those for minors, you can have a guardian of the person, which is, again, over their person, you dictate where they go to school, where they live, they're ensure they get medical care, that sort of thing. And to a certain threshold, you are their money. And if you go over the threshold, then the court can appoint you what they call guardian of the property. And you manage that property of the minor. For example, if they got life insurance payouts from a life insurance policy or something of that sort of from their parents' estate, that you're the guardian of those assets, and you're going to administer it for the benefit of the minors. You're even going to administer it in accordance with the same duty as a trustee has. That's your duties are the same. The duty of impartiality, to account, all those things, intact prudently. But if there's assets that the parents or anybody left in trust, maybe the grandparents, the guardian of the property does not have control over those assets. That's the trustee, still their purview. So it's important not to mix up those two. Also, when there is a trust in play and you're setting up a guardianship, it's prudent to think about, do we even need a guardian of the property? Maybe it makes sense to have the trustee, by agreement, everybody transfer the assets into the trust, or by court order that the trustee will manage the assets, whatever assets just happen not to be in trust, so that you don't have two administrators essentially. So when you're going through these different players and how your trust is going to interact, think about, some of the pros can be in trust. Using the trust, you have wide discretion to set your terms and conditions, especially with regard to age, which is usually important when you're dealing with minors or people who are going to become of age. And then you have the ability to use a third party, which, we talked about, helps with the trust issues. Are there any cons? Well, normally people would see it as a positive when you don't allow children access to property before age 18. They can't usually own or take possession of property before 18. So, but some people may see it as a con if they have to wait longer than that. The trust is imposing a longer period of time where they can't access their property. Probably the biggest con is costs. There's always cost to administering assets. And that's why I kind of pointed out the trustee versus guardian of the property. That's sort of a pet peeve of mine. Unless there's an overriding reason, I don't know why you'd have two roles like that, other than sometimes you have different parties involved and different parties want to have, some kind of control over the guardian or the minor's assets. But what a waste of administration cost. You've got two people that in theory can be paid a fee. You've got you're both essentially got the same duty. You're dealing with different assets. You've got to communicate this, to make sure that the minor has sufficient funds for different purposes and decide who's going to fund it. In that kind of sense, rarely do I think it is justified to have a separate trustee than a guardian of the property. In guardianships, I think the trend I've seen is judges recognizing that unless there's some reason that like the trustee just doesn't want to do it, there's no reason why the trustee who's already established, they're going nowhere. Why can't they manage any funds that just happen to be outside the trust? Let's look at section 4. Premarital agreements, when we know commonly as prenuptial agreements. In Florida, any state has a provision for premarital agreements. And in Florida, we have it under Chapter 69, Section 69.071 to be specific. That's where you get your definitions. It defines a premarital agreement as an agreement made in contemplation of marriage And in Florida, to be valid, you have to tick off some boxes. One has to be in writing and signed by both parties. Has to be voluntary. Cannot be the result of fraud, duress, coercion, or overreaching. And the terms have to be conscionable. Now, you don't have to be a lawyer to recognize there's some terms being used there that are certainly circumstantial. You probably have heard, and it's certainly commonly practiced, that you need full disclosure before a party enters into a premarital agreement. That goes to the more of the voluntary, not a result of fraud, duress, coercion. Full disclosure of assets means that it's harder for the party to later on argue that I didn't understand specifically what I was doing, or I was led to believe that the assets weren't as substantial, or the income wasn't as substantial, and things of that sort. So that's why, while it's not listed as a specific requirement to be valid, it's typical in practice, because it's a way to counter and shore up against any claims of fraud, duress, coercion, overreaching, or unconscionability. They have full knowledge of the assets and what they were doing, then it's harder to argue those things. So if you have substantial assets enough that you're looking at premarital agreement, what's become somewhat popular in Florida, I would think in other states, is maybe in lieu of a premarital agreement, should we do an irrevocable trust? So as we talked about before earlier, irrevocable trusts are transferring assets to a trust, and you can't undo that. You can't take it back. It has to be administered by the trustee in accordance with the trust. And there's no backseat, so to speak. So if you look at Florida premarital agreements law, as anybody who practices in this area knows, and I just tangentially get involved in some of these issues, but even I know there's a plethora of case law out there, because later on when someone's getting divorced, as you can imagine, if they got the wrong end of the premarital agreement, there's certainly an incentive to try to come up with a good argument to either modify or invalidate the agreement. So you sometimes practitioners will say you need a backup. Maybe you don't want to just depend on your premarital agreement, and the thought of irrevocable trust may come up. So let's look at this. Let's look at trust assets and premarital agreements. What are some issues? Why would you do that? What are some mistakes that people make? Let's kind of, I envision this as more of a thought of thinking through the process, and obviously a lot of it depends on what's involved. So you have an interest in, or you want to you have a substantial asset, and you want to endeavor to make it unreachable by your spouse, even when subject to a premarital agreement. If for some reason the premarital agreement fails, you want to have it in safe place, saying, well, it's not even mine anyway. I don't own it. I'm just a beneficiary of it. So can you do that? Well, in theory, it's actually a tool that's used. Understand that the more control you have over the asset, the more you use it, especially during the marriage, the more the court may think the irrevocability and the separation is a fiction. Especially if you're commingling assets. It's what advantages or disadvantage. I don't know if there's one over the other. I think the way I've seen it presented to folks is usually as two levels of protection. In both cases, I think you got some disclosure issues. In the premarital, you want to disclose if you've transferred anything to trust. you want to be clear on your intentions of in that trust on who it's to benefit. You still got to worry about commingling and control issues, because the trust assets can become de facto marital assets if they're used that way. There's nothing that's going to be bulletproof just by having an irrevocable trust, but it's certainly another level of protection if that's a primary concern, and they are used in common practice. So, but be wary of some common mistakes. Premarital agreements, for example, we went through the requirements. And as set forth in section 69071 Florida statutes, those provisions do not alter or alleviate like more formal requirements that may be required like under Florida's probate code and testamentary provisions that are oftentimes found in trust. I'll give you an example. You have some kind of waiver of spousal rights in the premarital agreement. You're waiving elective share, you're waiving homestead or other issues that or other provisions that under the Florida probate code or as a matter of law, you're entitled to as a spouse. Well, the premarital agreement is good with a signature and 2 witnesses, but it's not going to be good under Florida probate code. It requires those kind of waivers to have be signed in the presence of 2 witnesses. And they all, and just like in a testamentary provision, like a will, everybody has to be in the presence of everybody. Again, 2 witnesses, but the presence issue that you find in testamentary provisions and Florida probate code is not listed under the provision in the premarital agreement. So, coming in, signing it, having someone witness it, they leave the room and someone else come witness it, it's probably perfectly fine under premarital law, but it wouldn't be fine under Florida probate code, and it probably wouldn't be seen as a valid spousal rights waiver. Similarly, you can have provisions in a premarital agreement that are affirmative that says you will do certain things. You will leave your spouse this upon an inheritance, or maybe because they're waiving elective share, so you're going to give them this or that. An agreement to make a will or a testamentary trust. Again, it requires that presence, the 2 witnesses in the presence of each other. In probate terms, we call that self-proven. You usually like to have an affidavit with a notary there that says, yep, everybody was in the room. We all signed it together. The witnesses signed it. The person making the provision, grantor, signs it. And the notary signs it, swearing that happened. So again, that's just to point out where if you've got a complicated premarital agreement, you're getting into testamentary provisions or probate provision. Make sure you head over and check your probate code and make sure you've got things on in place that that are valid for all of those purposes. And I would even point out now that we have the provisions of the that require us to have the witnesses on anything that transfers real estate. Witnesses have to have their addresses on there now for that to be recorded. To the extent that there may be some real property described in the premarital agreement that acts as a transfer, to the extent this may need to be recorded as public property in the public record one day, I would add that into my form premarital agreements as well to make sure the witnesses put their addresses down, just in case there needs to be a recording later on. So, like I think I referred to earlier, is there's a lot of case law on premarital agreements and how they interplay with when there's trust involved. And I want to illustrate how overlapping and really confusing even to lawyers who practice in these various fields, the case law can be, because you're dealing with so many different provisions from different statutes and common law. I want to give you the Wilson versus the Paul C. Wilson Trust case as an example to kind of illustrate what we have going on here. That's a 4th DCA case. It's from 2019. The facts were interesting because as I went through them, I thought it was going to have a different result. So the facts are in short form are this. There was a premarital agreement in place, had an elective share waiver. Presumably all their execution requirements were there. The spouse that that had the benefit of the premarital agreement at a later date did some estate planning, and not sure why in his trust. Maybe this was just form, or maybe he intended, but he had some provisions in there that talked about that his spouse would be entitled to the elective share upon complying with the statute and making her waiver. And some provisions on how the elective share should be paid out, essentially from what assets. Well, so you have an elective share waiver in the prenuptial, but you also have this trust provision made afterwards that seems to contemplate that maybe she will take an elective share. The party arguing on behalf of the elective share waiving spouse, which I believe was the wife, argued that, well, clearly, he's the husband's changed the prenuptial requirement. He's decided that she does get an elective share and unilaterally changed it. He lost on that argument because the court reasoned that because it has to be in writing, the premarital agreement has to be in writing, signed by both parties and witnesses. Any modifications there too would have to similarly be put in writing and signed by both parties. You can't essentially have an implied modification. I thought, when I initially read the facts, I saw it going the other way because it seemed like that's an odd provision to put in your estate planning if your spouse has already waived the elective share. But that's how the court fell on those issues. After applying what the elective share law says, after applying what the trust law says, and what premarital law says, coming from 3 totally different sections of Florida code, and trying to reconcile how did those interplay in this circumstance. And that's just one of many examples you could probably think of, and that have been litigated where these different issues come into play. And just having knowledge about one of the 3 or one of the 4, or however many are coming into play, may get a practitioner in trouble. So we'll come back, we're kind of wrapping back around to what's the purpose of today's seminar. I want to kind of show the interplay, go over the basic tenets of law of these different provisions of trust law and different aspects of family law. And but show how they can interplay and how the issues aren't always clear as to which provisions should control or how they should be reconciled. If you're like me, I like knowing some really good divorce attorneys, family law attorneys to use as a resource and to even work with. And I encourage all of you practicing in one of these areas to have the same kind of resource, unless you're just really good at being knowledgeable as to all of these different areas of law. There's an intersection. There's certainly an interplay of these different issues. And going forward, I hope that it helps you to be more mindful of how different things can come, different sections of the law can come into play into what might look on the face as a simple trust matter. Thank you for joining us today.